What they did is they improperly weaponized this charge called 18 USC United States Code 1512. It's a obstruction charge that comes from the Sarbanes-Oxley Act. It has to do with Enron. When Enron was being investigated, Enron famously collapsed about 20 years ago. When it was being investigated, they knew the DOJ was coming. So everybody was like, yo, shred everything, right? There was no law on the books that really could attack them. So after that happened, they shredded these documents in anticipation of litigation. They put this charge in the books. They said, if you tamper with evidence for the specific purpose of jamming up a judicial proceeding, we're going to charge you with it because we can't get you for what you did, but we get you for obstruction. Right. So they expanded the scope of that charge to say that anybody who showed up on the Capitol that day, if you had the intent to obstruct the count or the certification, you're on the hook for obstruction. Wow. We were saying from Jump Street, this shit is wrong. Right. What you guys are doing is wrong. It's unconstitutional. And what are they saying? F you, appeal it.
And this is what happens also in regular criminal justice system. Take the ride. Because you get the wrong judge, you get a gun case, you just say you have a really good suppressible case, right? So that means, look, the guy had the gun, or, the cops found a gun on him allegedly, but the way they went about it, it's gonna get suppressed because they just pulled up on him, stopped and frisked, you driving while black, whatever it is, right? So it's gonna get suppressed. But you have some judges who are like, I don't give a fuck. Like, I know he had the gun, or I believe he had the gun, and regardless of whether he should be suppressed, I'm not gonna suppress it. Even if what I'm doing is clearly appealable, so that this guy takes the ride, he goes upstate for 2 years, 3 years, it gets appealed, his conviction gets overturned, but at least give him the ride.
Yeah, you asked out at that time. So the process is the punishment.
Exactly.
The process is the punishment. So what happened? We fought this. We everybody got behind each other, and we all uniformly, really went after this charge. I engaged on a public, campaign on the media and on TV and all these shows. Other people engaged in the Supreme Court, and just today, the 1512 charge got shot down by the Supreme Court. So mad people. Some people already did their bid. 4 years, they're done already, right? They didn't have to do it.
That's crazy. So, but now, are they able to sue, or?
It's an interesting question. I think they would have grounds to sue.
I mean, I'm not a lawyer, but I would still like if.
Yeah, it's a wrongful conviction if you ask me. And so they limited the scope of the application to say if you touch the documents, then you're on the hook for this charge, because that's what the legislators intended, right? Okay, I can understand. Guess how many of these people touch documents? Not one. Not one.
I mean, well, if you put your feet up on a desk and there were documents on the desk and your foot was on the
Even
paper,
then, the intent would have to be those documents. You would have to have displayed the intent somehow to want to grab those documents for the specific purpose of obstructing the certification of the vote. Right. And so if you just kick documents off because you're being a schmuck.
Yeah.
Right. You're trespassing. You're loitering. You're breaking and entering. That's one thing. But you're not doing what they accuse you of. And the reason why they use this charge, because guess what? It's 20 years out of the gate.
Yeah.
Oh,
so shit. You've never had no contact with the criminal justice system. You showed up, you're 65 years old, you're with your wife, she's 65 years old, you take a walk in the Capitol. You're like, yo, 20 years or take this plea deal for 4 years. People just sign their lives away.